Okay. The Arizona State Board of Education Professional Practices Advisory Committee will please come to order. Kellen, will you call the roll?
Chairman Sampson.
Present.
Member Correa.
Present.
Member Kreider.
Present.
Member Harris. Member Sadorf.
Present.
Member Sneed.
Present.
You have a quorum.
Thank you, Kellen. Okay. We call the case of Arizona State Board of Education v. Christopher Chinchilla, case number C-2017-425-R, C-2017-425. My name is Prudence Lee. Today, May 8th, 2018 at 9 a.m. is the date and time set for the disciplinary hearing and application for certification for Christopher Chinchilla, as set forth in the complaint and notice of hearing. Present to hear the testimony and for deliberation and decision are members of the Arizona State Board of Education Professional Practices Advisory Committee. This hearing is held in accordance with Arizona Revised Statutes, Section 15-203 and Arizona Administrative Code, R7-2-701 et sec. I am the hearing officer designated by the State Board of Education Executive Director to conduct the hearing in this disciplinary matter and application for certification. This hearing is being recorded by a court reporter and video recorded. Therefore, only one person should speak at a time, and anyone speaking needs to speak up so that the microphone will pick up what is said. Would all other persons please identify yourself for the record?
Garnett Winters, Chief Investigator, Department of Education.
Soyika White, Director of Special Projects, State Board of Education.
Eric Schwartz, Assistant Attorney General on behalf of the state.
Christopher Chinchilla.
Kellen Wesley, Executive Assistant, State Board of Education.
Thank you. This hearing will consist of opening statements by the parties. These are optional. The presentation of evidence will follow, with the party with the burden of proof presenting first. In a disciplinary hearing, the state has the burden of proof, so will present their evidence first through witnesses and documents. The other party has the right to ask questions of the state witnesses and to raise any legal objections to documents offered into evidence. The hearing officer reserves the right to ask questions of the witnesses. Committee members may also ask questions of the witnesses. After the state concludes its presentation of evidence, the other party may present testimony and documents. The state's attorney may question any person testifying on behalf of the respondent, including questioning the respondent. At the conclusion of the presentation of evidence, closing argument will be heard. At the conclusion of the hearing, the committee will deliberate and decide whether to dismiss the case or take appropriate disciplinary action and to grant or deny the application for certification. The state must prove its case by a preponderance of the evidence, which means it is more likely than not that the facts occurred as asserted by the state. In an administrative hearing such as this, the formal rules of evidence do not apply and hearsay is admissible. Parties may object to evidence on certain narrow bases, such as relevance. Are there any preliminary matters from the parties?
If we'd like to deal with exhibits now, we could. And Mr. Chinchilla has submitted some additional documents we could need to deal with also.
All right.
And I already spoke with Mr. Chinchilla, and he's agreed that we'd stipulate to the exhibits 1 through 14 that were sent along with the complaint, and then I have no objections that would stipulate to the 3 additional packets or 3 additional exhibits that he submitted, if you want to mark those as whatever, 15, 16, 17 somehow.
Okay. If you don't mind, Mr. Schwartz, I'll mark them as respondents, exhibits 1, 2, and 3.
Okay. And I'm just, which one is 1 and 2 and 3? Just.
Pardon?
Which one is 1, 2, and 3?
Oh, I'm sorry. I'm starting with a letter to whom it may concern as Exhibit 1. Then there is it's entitled OPCOM Records Request Form Submitted, Exhibit 2. And then a partial transcript from the court, the Superior Court in Yavapai County as Exhibit 3. Thank you. Exhibits The State's Exhibits 1 through 14 are admitted into evidence. Respondent's Exhibits 1 through 3 are admitted into evidence.
And then I guess if we could just mark as Exhibit 15 then and admit the notice of hearing and the certified mail receipt as Exhibit 15.
All right. Mr. Chinchilla, do you have any objection to that?
No, I don't.
All right. Exhibit 15, the notice of hearing, and I'm sorry, what else was it, Mr.
The certified mail receipt.
Certified mail receipt are admitted into evidence. Are there any other matters to discuss?
The only other one is I had submitted a proposed findings of fact, conclusions of law, recommended decision to the PPAC, and I gave a copy to Mr. Chinchilla. I just asked that that be marked as document 1 and included in the record.
All right. Any objections, Mr. Chinchilla?
No, I don't.
All right. The proposed findings of fact, conclusions of law, and recommendation are marked as document 1 and become part of the record. All right. Anything else?
I don't have anything.
All right. I will now swear in the witnesses. Do you have any witnesses, Mr. Schwartz?
I do not.
All right. Then the only person we're swearing today, Mr. Chinchilla, do you plan on testifying?
Yes, I do.
Please raise your right hand. Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
Yes, I do.
Thank you. All right. Mr. Schwartz, do you have an opening statement?
Yes. Okay. Members of the committee, the evidence will show that as of May 7, 2017, Respondent Christopher Chinchilla was employed as a teacher by the Tucson Union High School District. The evidence will also show that on May 17, 2017, Respondent was driving his car back home to Phoenix from Las Vegas when he became involved in an incident with another vehicle on the highway in northern Arizona. Respondent then decided to try to resolve the incident by pointing a loaded firearm out the window of his vehicle at the other vehicle, which was occupied by a husband and wife. When the police arrived, they not only arrested Respondent on 2 felony charges for pointing the loaded gun at the other vehicle, but the police also discovered that Respondent was driving on a suspended license, that he had no mandatory insurance on his vehicle, and that his vehicle's registration was expired, and they arrested him on those charges also. Now I understand that these additional charges might seem like trivial violations compared to pointing a loaded gun at an occupied vehicle, but they're further evidence of Respondent's apparent disregard for the rule of law. He never should have been driving that day in the first place, much less driving back to Phoenix from a trip to Las Vegas. Respondent quickly pled guilty to a Class 1 misdemeanor for driving on a suspended license and pled responsible for the 2 civil violations of no car insurance and no vehicle registration. He later entered a plea agreement regarding the 2 Class 3 felony aggravated assault charges he faced for pointing the gun, and he was allowed to plead down to 1 count of disorderly conduct with a weapon, to wit, a handgun, a Class 6 undesignated felony. He's currently serving 3 years of supervised probation for that conviction. Respondent's conduct on May 7, 2017 constitutes conduct which discredits the teaching profession, especially given the fact that he was employed as a certified teacher at the time of his May 7, 2017 arrest, and constitutes unprofessional conduct under Code Section R7-2-1308B15, which states that certificate holders shall not engage in conduct which would discredit the teaching profession. For the foregoing reasons, the state requests that the PPAC recommend to the board that it take disciplinary action against any and all of Christopher Chinchilla's teaching certificates, and that it deny his application for certification. And on that, a little side note, just to clarify anything, if people were a little confused about the application for certification, because it's a little different. It's an application to remove deficiencies. So it's a little different, but just to make sure everybody understands, what that means is when Mr. Chinchilla, he was given a standard secondary teaching certificate, but only for 1 year instead of the traditional 6, because he had to, I think it was like a Constitution course. Or
AZ Constitution, yes.
Yeah, he had a deficiency, and he had subsequently has completed that, so he applied to remove that deficiency. And if that deficiency is removed, that would extend the period of the certificate to the original 6 years. So in essence, it is an application for certification because it could result in his certification for an additional 5 years. So I just, in case anyone was kind of confused, because it's a little different type of application. In closing, I'd like to remind the PPAC that under ARS 15534.02b, if the PPAC votes to recommend denying the application, the PPAC must now also recommend a specified period of time, up to 5 years, that Mr. Chinchilla would be prohibited from submitting an application for certification. Additionally, because this is a combined complaint and application hearing, if the PPAC recommends disciplinary action against Mr. Chinchilla's existing certificate, it would seem to make the most sense to match any period of disciplinary action imposed on the existing certificate with the period that Mr. Chinchilla would be prohibited from submitting any application for certification. Thank you.
Thank you, Mr. Schwartz. Mr. Chinchilla, do you have an opening statement?
Do I stand? Board members, thank you for being here today. I want to make one point very clear. I'm not here to deny or to refuse accountability for the incident that happened on May 7, 2017. The reality is I took a plea agreement on the matter, and I've already admitted guilt to that. This is something that's been truly embarrassing for me, and I've suffered great loss because of it. There are reasons, though, that I'm here, and it's to offer evidence of several mitigating factors which clearly highlight how my actions of the day and that incident were not malicious or not acted upon with criminal intent. And that the crime itself, which I openly admitted to, is not indicative of my personal character or reason to doubt my professional fitness in the classroom. Thank you.
Thank you, Mr. Chinchilla. So, Mr. Schwartz, you don't have any witnesses?
No, I don't. I was just thinking Mr. Chinchilla could present his evidence, and then I could cross and would be done.
All right. So the state rests?
Yes.
All right. Mr. Chinchilla, you may now testify or present any witnesses that you may have, including yourself.
Well, this is a little out of order from what I've read that procedurally happens in this. So I'm not exactly sure how to, but I think explaining the incident would probably be the best step. On my way home from Vegas that day, I was being tailgated by an aggressive driver. When the driver went to pass me, this is not a cut, and didn't cut me off. He literally ran me up onto the side of the road, onto the shoulder of the road. It's the most aggressive move I've ever been subjected to on the road. I've been driving for 22 years. And it didn't stop there. When he got in front of me, then he jammed on his brakes, and I had to swerve my car to the right, okay, in order to avoid him. And I found myself again sitting right next to him, this time on the left side. Out of fear of my life, I reached over and grabbed the 9mm handgun that I carry in my car. Okay, I carry it always. It wasn't something that I reached for prior to that. It's always between my seat, which it's legal. It's something that was registered to me. I did it 100% out of fear of what was going to happen, and I pointed it over at the car. When the driver then sped forward, I immediately exited on the very next exit. And the reason I did that was to diffuse the situation. I had no intention ever of escalating the situation. I didn't want to antagonize it in any way. What I have brought is a document from the 911 call. And if you notice on the very second page, the very first entry, it says at the bottom, the suspect exited on Fort Rock Road. That was the victim in the case. He actually said those words. So it does confirm that I definitely did try to remove myself from the situation with every intent to diffuse the situation from what it was. It would be under entry 1353, in case you're having trouble finding that. After the situation eased off, I waited 5 minutes on the road there, and before I got out of my car and just tried to create enough separation for myself and the other driver to not have the incident reoccur. And it wasn't until later that I was pulled over that I realized that I was made aware that what I had done was a crime. I never turned around. I never tried to flee that situation. Okay, I did not in any way think that what I had done was criminal because I was 100% just trying to protect myself at that moment. I've never been more scared than what I was in driving that day. I don't say those things to try to not take credit for or be not accountable, because they've made it very clear to me that brandishing a weapon is a crime, and I definitely understand that. But again, there was no malicious intent whatsoever when I pulled the weapon. Furthermore, the issue itself, it's caused me a lot of distress, and I felt pretty hopeless at some times. My fingerprint clearance card had been suspended, and so that was the reason why I ended up resigning from Sierra Linda High School. After I took the plea, my fingerprint clearance was returned to me, and I have it active right now, and I am teaching currently. The biggest thing that made me want to go back into teaching after this, because I kind of felt like it was going to be hopeless, were some of the words that the judge said during the sentencing. The judge heard both sides of the incident, and if you turn to the transcript that I provided you with, on the second page, the judge stated that I understand from 17.4 how you perceived things that happened that day and felt that you had to resort to what you did by brandishing the gun and pointing it at the victims. After learning all the things I've learned about you, I don't think it defines you. In this case, in this plea, recognizes that you accept responsibility, that you screwed up and you made a mistake. But if anybody could sit here and say that they never made a mistake in their life, they wouldn't be human. So yes, there's consequences, but perhaps you can pursue your passion with this plea. I hope very much that you can. Mistakes that you made, actually it was a crime, and you came back here. I see a lot of individuals come back here time and time after probation with other felonies. That doesn't shake out as a human mistake. That shakes out as criminal. I'm not looking at a criminal today, and I don't think you are one, and I think you're going to be successful on your probation, and I think that with your training and experience and your love for coaching, that it's going to continue. I certainly hope so. So what the judge said that day really made me feel like it was going to be a possibility for me to get back into teaching. And so even though it was embarrassing, it is, I have to go and apply for jobs with a felony on your record and have to explain those circumstances, I went right back out and did just that. I was able to gain employment at Gateway Middle School, where I've been working since January, and I provided 3 letters from staff at Gateway. One from the principal, that's the very first letter from Andy Gutierrez. The second from the community worker, he works with the Creighton Community Foundation. And the third from the girls softball coach there, which I also participated in that as a volunteer. It's my most sincere hope that the board members here can understand the circumstances of the unfortunate situation that that I put myself in. And I do want to point out that I think, considering the school was able to recognize they were given full disclosure of what happened in that incident, and they were willing to give me a second chance. And I think some of these letters definitely are testimony to how I've repaid that opportunity as well. I hope the board can give me that same opportunity.
Anything further, Mr. Chinchilla?
No.
Mr. Schwartz, do you have questions of Mr. Chinchilla?
I do. Okay, Mr. Chinchilla, I'm just, you were just testifying. You said, did I follow this correctly? Said that you pointed the gun at the other vehicle, and then you exited the roadway to diffuse the situation. Was that what you said?
Yes.
I guess my question is, why didn't you just exit the roadway to diffuse the situation instead of pulling out a gun and pointing it at an occupied vehicle on the highway?
That's definitely something that I've thought about considerably since this happened. I realized that that's the biggest mistake that I made here today. When I was being attacked, I didn't think of anything else other than to immediately reach for something to protect myself, but realized that once the person backed off, I was able to get my thoughts together and remove myself from the situation altogether. It happened so fast that it really never occurred to me to do anything other than to protect myself from my immediate care.
So is there any reason you couldn't have just exited the roadway instead of pulling your gun?
In hindsight, when the person was tailgating me, I should have pulled over right there and called the police. That's
Okay.
how the situation should have been handled. That's definitely my mistake.
Okay. And you said also when you were talking about the judge, the exhibit you offered about the judge's statements, you said the judge heard both sides of the incident. This was a plea agreement, wasn't it?
Yes. Before the plea happened, the prosecuting attorney presented his evidence, and my public defender also presented the evidence a lot like what I have presented here today.
So did the prosecutor call witnesses?
No, he did not call witnesses. He took the testimony directly from the victim.
Right. Okay. So at the time you were arrested, you were employed with Tucson Union High School District?
Yes, that's correct.
And you ultimately resigned from there after this incident?
Yes, I wasn't actually. My address had changed, and the notification of my fingerprint clearance card was sent to my brother's old address, which he's not there anymore. So I wasn't notified that my fingerprint card had been suspended until just a few days before I ended up resigning.
So is the answer to the question yes? You resigned from Tucson after this incident?
Yes, that's correct.
And you were charged with 2 counts of aggravated assault, a Class 3 felony, originally in court, correct?
That's correct.
And then you got a plea deal and were allowed to plead guilty to 1 amended count of disorderly conduct with a weapon, a Class 6 undesignated felony, correct?
That's correct.
So as you sit here today, you're a convicted felon, is that correct?
That is correct.
Okay, and you're currently sentenced to 3 years of supervised probation that began on November 3rd, 2017?
That's correct.
Okay. And along with being arrested for pointing a gun at the other vehicle, you were also arrested for driving on a suspended license, driving with no mandatory insurance, and driving with an expired registration on your vehicle. Is that correct?
That's correct.
And you were convicted of a Class 1 misdemeanor for the suspended license and paid fines for the other 2, correct?
That's correct.
And so according to the police report, you said you were returning to Phoenix from Las Vegas at the time you were arrested?
Yes, I went to go see my fiance, who's in Vegas.
Okay, so you just went on a pleasure trip to Las Vegas?
She lived in Idaho, so since she was only 4 hours away, I definitely wanted to take advantage of the opportunity to go see her.
Okay. So you had no license, you had no insurance, and you had no registration, but you thought it might be a good idea to take a joyride to Las Vegas?
I realize now that it wasn't a good idea.
Okay. And according to the police report, when you were asked about the suspended license, you said it was because you hadn't paid some tickets?
That is correct.
And also according to the police report, when you were asked about no insurance and no registration, you said that shit is expensive.
That's correct.
Okay. So you couldn't afford to pay for registration or insurance or tickets, but you could afford to take a trip to Las Vegas.
Again, I didn't go there to gamble or anything like that. I just went to go see my fiance.
Okay.
But I understand how it looks. I definitely understand.
Okay. And again, I just want to make sure I'm clear that you heard my explanation, my opening about the application to remove deficiencies. Did I accurately describe what that is? That if the you have satisfied the requirement to remove the deficiency, and if it's removed, it would extend your secondary certificate 5 years, basically.
I understand.
Okay. I just want to make sure that I was correct on that. Okay. I have no further questions.
All right. I have a question. Mr. Chinchilla?
Yes.
The information talked about an undesignated felony that could possibly be removed in 3 years. Could you explain that to us?
So the difference between a designated and an undesignated felony is that the undesignated has the opportunity to be designated a misdemeanor once the probation period is finished. I'm eligible to apply for that after 18 months.
Thank you. I don't have any further questions. Does the committee have any questions of Mr. Chinchilla?
I do. When will that 18-month period be up?
I believe we're, so since November, so I think we're 7 months in or so.
Okay.
So probably close to about a year from now.
Questions?
Go ahead.
So you were driving on a suspended license. Can you explain why your license was suspended, sir?
This license was suspended for a failure to pay, or really just because I got behind on court payments on other traffic violations.
How many other traffic violations?
I believe it was 2.
And so the court suspended your license because you had too many points?
It's not, it wasn't, oh, actually, no, it wasn't a point situation. It was just because I was behind on the payments.
Okay.
Yeah.
Thank you, Mr. Sampson. Any other questions? Mr. Correa.
Just to clarify, you said you resigned from Tolleson Union. What was the reason again? I know you mentioned, I didn't hear it.
Well, my fingerprint clearance card was not active at the time, so I was actually reassigned to home. The biggest reason for the resignation was because since I was out of work, I needed to cash out my retirement.
So they notified you that your fingerprint clearance was expired?
Suspended.
Suspended?
Because
you were not aware of that?
No, I was not.
Any other questions? Mr. Sampson.
Yeah, I've got further. There are more questions about, well, I just want to talk to the Mr. Chinchilla for a sec, with your permission. Having read the statements and read the documents beforehand, I had a very different perception than what I do now. Realizing that in today's day and age, it is quite a risk to recommend certification of an individual who's brandished a weapon. And I'd like you to just talk a little bit more, at least to me. I don't know if other members of the committee are interested, but I want you to talk a little bit more about how I can find some security in recommending your certification, that this was a one-time incident, that this isn't a pattern of bad behavior, because that we need to make this recommendation to the state board, and it is a risk. In today's day and age, anything involving a firearm is, attached to the name of the hearing body that is going to recommend that. So need to know what additional assurances you could give this hearing body as to this is a really bad road rage incident that got out of hand and kind of threw your life sideways, and not a continuous pattern of bad behavior.
I definitely understand. I'm not too sure as far as concrete guarantees that I can make that I can show you today. What I can say is that I'm a 4th generation teacher. Our teaching roots go all the way back to Costa Rica on our dad's side, and Germany on my mom's side. Education is everything in our family. And I made a decision to go back to school at 28. This is in 2007 when the bubble burst on mortgages. I was doing mortgages for 4 years, and I found myself without a job and without a degree and really no job security whatsoever. And I had a 4-year-old son at the time. And what I realized then is I needed to do something that would give me, like a permanent foundation. And the only thing I could think of doing at that time was following in my mom's footsteps and becoming a teacher. And it was a great honor for me to graduate. I ended up graduating with honors from college. My son was able to see me walk down the aisle that day. It's really a sense of pride for me. And it's very humbling for me. It's very embarrassing for me to have to be here and explain the circumstances. I definitely know that I made the mistake, and I understand the concern that the board has with licensing someone who brandished a firearm. I definitely understand. I can only say that, every day that I go to work, it brings me joy. And being back in the classroom right now after this incident has really lifted my spirits quite a bit. I've become very attached to the 8th grade class that I'm currently teaching. And these kids here had 6 teachers over the first semester of school alone. And the way I got them to buy into what I do in the classroom was I guaranteed them that I would be there, rain or shine, every single day, and I'd be there at their graduation. I really hope that the board can approve this and allow me to be there with this class to graduate. On that note, this would have been my 4th year at Sierra Linda. I only teach freshman classes there. And my first year, I coached all freshman teams. So to not end up being there for this graduating class after spending so much time with them absolutely breaks my heart. And I really hope to be able to reestablish that rapport with this new school and move on with my teaching career.
Do you have follow-up, Mr. Sampson?
I do. On a different day, your principal that wrote you, they're all very much aware of the situation you were in.
All three of those letters, and they actually stated in the letters themselves, they are fully aware of the circumstances of the incident.
Okay.
As well as the district office at Creighton as well.
Okay, and they have your full support. You have their full support.
100%, and they've offered me a contract for next year as well, provided that I can have this situation rectified.
Have you had any probation violations at this point?
Absolutely none.
Okay.
I just have some more.
Mr. Corey.
To clarify. So your fingerprint clearance card, that's been restored?
Yes, it was restored immediately after I took the plea deal in November.
And the other infractions, so your other traffic violations, what are they a result of?
I believe just basic, like a red light kind of situation.
Are you sure about that? Are you just?
What
exactly are they?
I know I have a red light. I think it was a turn on the stop sign, and I believe the other one was a red light as well.
So both of those were. I guess so. The question is that I want to get a sense of. Do you have a pattern of road rage, right, or driving inappropriately, and causing and being pulled over for those kind of behaviors? So I appreciate your candidness, and just explain to me the other infractions.
Sure. The one that I definitely remember was I was following a friend of mine, and she turned on a red. This is in the East Valley. There's quite a few no turn on red signs, but since I was following her, I just wasn't looking at the sign itself, and I just kind of followed her right through. The officer who pulled me over, she stopped as well, said that I got pulled over because I was the car behind her. He basically just had to choose between the two of us, and he chose me. But it really just I don't know, error in judgment, not necessarily error in judgment, but it just wasn't really paying attention that day.
And then the other?
I believe that's a red light as well, but that's quite a few years ago. But if I do remember, it was just one of those caught in between, yellow light, red light kind of situations, and I made a decision to go through it. But definitely not in any way road raging or anything like that. I'm a pretty casual driver. And in regard to the actual incident on May 7th, and this is definitely one of my mistakes, my car was set at cruise control at 85 miles an hour, which was the flow of traffic. I didn't want to move that from out of the way when he came up tailgating me, just because I was in just a relaxed mood, and I just figured I'm already going 10 miles over the speed limit. I just didn't see any reason to move or to speed up anymore to get out of his way.
Thank you.
Yeah.
Other questions from the committee? All right. Is there anything else, Mr. Chinchilla?
No, I don't have anything else.
All right, then that leads us to closing argument. Mr. Schwartz.
Well, it's pretty straightforward. Mr. Chinchilla, he's represented himself well here today, but I hear a lot of, I take responsibility for pointing a gun at a vehicle, but it wasn't my fault. And I pulled a gun and pointed at a vehicle, and then I exited the roadway to defuse the situation. These things just don't add up or don't match. Yes, he made a horrible mistake, but it's also compounded by the fact he never should have been on the road. No license, no insurance, no registration, but decided to take a pleasure trip to Las Vegas, and then on the road pull out a gun and point at someone. As he sits here today, he's a convicted felon. Yes, I included in the complaint and in the recommended decision the fact that as a Class 6 undesignated felony, there is the potential that down the road it could be reclassified as a misdemeanor, but that's dependent on future events. There have to be consequences for actions, and this is a pretty serious serious matter. And again, he's actually quite fortunate to end up with what he did get when originally charged with 2 Class 3 felonies. The evidence establishes that Mr. Chinchilla did engage in unprofessional conduct under the law and should be subject to discipline. The state recommends disciplinary action through suspension of any and all of his teaching certificates through November 3rd, 2020, and that date comes from, it's 3 years of probation. He was sentenced to 3 years of probation November 3rd, 2017, so through that period of probation that it's currently scheduled to end on November 3rd, 2020, and that the application for certification be denied and he'd be prohibited from submitting an application until that same date. Thank you.
Mr. Chinchilla, closing argument.
It was just mentioned that there's definitely consequences to actions, and I 100% agree with that. Some of the consequences that this action has actually caused me, I've lost my job, I lost my car, I lost my fiance, who was in another state because I couldn't go see her anymore. I had to move out of my apartment because I'm now a felon, okay, and I've lost freedoms. To say that I've already felt down or felt, the effect of this thing would be a radical understatement already. The things that keep me motivated and moving forward and staying positive are being around these kids that I'm around right now, being part of the community activities that I've been part of, and having the opportunity to do things like coach the girls softball team there at Gateway, which was an absolute pleasure for me. I really do hope that this board can understand the circumstances of what happened that day and give me the opportunity to go back and continue on the career path that I've laid out for myself. Thank you.
Thank you. Having heard the testimony, reviewed the evidence, the committee will now discuss the case. Is there any discussion before we look at the proposed findings of fact, conclusions of law, and recommendation? Mr. Sampson.
I do have some. I appreciate Mr. Schwartz very much. I appreciate his passionate arguments. I do, for the record, want to state my belief of what this committee does. This committee doesn't take licenses away and people's livelihoods and passion for teaching based on suspended driver's licenses. Even if that's bad decision-making, even if that's wrong. We do, however, take people's licenses away for burnishing of weapons and creating a dangerous situation and felony behavior. The question for me is not whether he was driving to Vegas on a suspended license. I understand the argument that's trying to be made there, but that does not carry the weight for me. What is interesting to me is, in this particular situation, is this is a dangerous felony. Does that translate into somebody that would be a danger to himself, others, and especially children in the classroom? And I'm not sure that it does. And that surprises me very much, because when I read the allegations, I thought I'm pretty strict, and I'm on anything that would be seen as dangerous to children in the classroom. I go back to the statements, which we didn't have at the time, of the judge who sentenced him. And he talks about making a mistake and the actions being criminal, but he says of Mr. Chinchilla, I'm not looking at a criminal today. He also understands, having seen all of the evidence presented by the prosecution as part of the plea agreement, that he says, I understand why you brandished a weapon and pointed at the gun at the victim. So I don't think that this was, I think there were two parties in this. I don't think Mr. Chinchilla was completely innocent and did it only in protective. I think it was a road rage incident, but that's neither here nor there. What I see is somebody who's taken responsibility for a very bad mistake, is working the process, and does not, in my opinion, based on letters of recommendations and other things, present a danger to children in the classroom. The concern I have, as I verbally process this through, is he is still on probation. If he had completed probation, I think it's a stronger it's a stronger foundation for which him to make. So far, he's completed a year of probation. That has gone very well. I look to finishing that probation is an excellent example. What the flip side of that is, he's currently working in a school, has strong recommendations from individuals he's working with in school. They are aware of the incident and have still offered him a contract for next year. So that's where I'm at, and I would love to hear other committee members' thoughts on that before we get into the findings of fact and conclusions of law. I'm not, based on the evidence that has been presented today, I am loath to throw away a teaching career because of a very bad incident. That being the case, I realize that it's a heavy lift for anybody in this committee to recommend the continued certification of an individual who has burnished a weapon in a road rage incident. So I realize other committee members may not be where I am, but I wanted to put that on the record. Hear from all of you.
Dr. Sadorf.
Hearing Officer Lee, thank you. Member Sampson, I understand exactly what you're saying, but even though the judge did make some pretty positive statements of intent, he was still given some probation time and requirements as a result of that decision he made on the road. I understand, too, that this was not just a one individual situation that was created on that road. There were 2 cars that were involved. And I really have no doubt that the other car was as at fault, just looking at the situation. My concern is to allow a certificate to an individual that has a felony, that is currently on probation, to be in the classroom with students as a role model. I don't know if that sends the right message. And even though we have very good letters of recommendation from the people that he's currently working with, I have a hard time saying, yes, we should allow him to continue in the classroom at this point. I would feel a lot more comfortable, as you indicated, he has successfully completed a year of probation. I would feel more comfortable having him come back after he has completed that probation. I think you're right. He does stand in better stead, a stronger case to show that he is able to learn from the mistake, move on from the mistake, and at that point, potentially not even having a felony on his record, depending on what the courts decide to do at the end of that probation. So I understand where you're coming from, but I think that we would be doing our profession a disservice if we recommended that there are no consequences from certification.
Ms. Sneed.
I, too, have a very different feeling right now after meeting you than I did when I was reading the paperwork. I appreciate that you are following the process, and it probably seems like it's a long, tedious process to you. I think you would have a much stronger case if you could get rid of the felony. If you could go through the process, finish the probation, and try to get that reduced to a misdemeanor, I would feel much more comfortable approving it at that point, for the same reasons that my peers have mentioned.
Anyone else? Mr. Corio.
In many ways, I feel similar to my colleagues in terms of having that felony. Right, that's a tough one. Though I just wonder. He's currently employed in a school, and by all accounts here from the documentation, he's doing well. So, that's the only wrinkle in the thinking. But I think since it's now on our docket to review, I think the message of allowing for a certificate when a felony is still active is very difficult. Though I do appreciate the respondent's candor and taking responsibility for his actions. It's a lesson learned here.
Mr. Steiner. Reiner, I'm sorry.
I too echo the sentiments of fellow board members. When I initially read through this, I had a picture in my head of the actual incident, a picture in my head of what the individual was probably going to present, and then as the events of today transpired, that picture kind of got a little more cloudier, or maybe I moved back towards the middle of, now I'm stuck. And I agree with what almost everyone has said in some way, shape, or form, where we have a individual who has a passion for teaching, a passion for being in the classroom, and has done well when he's been there. And now we're looking at an incident that is separate from the classroom, but because of what the incident involved and the society that we live in with weapons and firearms and things of that nature, I'm stuck right now. And the probation thing is a big thing. If the probation thing was done, then I would obviously lean one way more heavily than the other, but that's what kind of weighs on my mind right now.
Go ahead, Mr. Sampson.
Thank you, Hearing Officer Lead. I want to make sure I understand the process. I was understanding that this was brought forward as a complaint, and it's a complaint in application. And I'm Hearing Officer Lee, if you allow me to ask counsel a question about process, or maybe I'll ask you and you can determine whether counsel is appropriate. I'm trying to see, did the application trigger the complaint, or was the complaint coming and we were rolling for efficiency as appropriate the application into the complaint?
I'll allow Mr. Schwartz to answer because I think I know the reason, but let's hear it from Mr. Schwartz.
That would probably be a better question for Ms. Winters.
All right, Mr. Winters, I need to put you under oath. First of all, is there any objection to reopening the testimony in this hearing? Hearing none, do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
I do.
All right. Can you answer the question?
Yes, we had a complaint. DPS reported the arrest for the incident, so we had an open complaint, and then he submitted his application. So then it was open for review. So it was open for review, and
excuse me. I'm still getting used to having an excellent hearing officer here, and it's not overriding all the rules. With your permission, Investigator Winters. So it was the application that triggered first.
No, it was the complaint, the arrest.
No, I understand that you had a complaint, but do you guys bring a complaint? You were planning on bringing this as part of the complaint schedule.
Yes.
It wasn't part of the application schedule.
Correct.
Okay, that's helpful. Did you understand my question? Because I didn't think I was very clear.
I did, yeah.
Because there's two processes. There's an application process, a complaint process. I wanted to see, because and let me, now that I've made a mess of everything, let me explain why I think that's important, is because if this was based on the application process, it's simply a matter of suspending the application or withdrawing the application. He's still got a valid substitute certificate that would allow him, if the school agrees and can figure that out, allow Mr. Chinchilla to continue to teach. Once the completion of probation is done, then a reapplication puts him on stronger footing. If it's a complaint process, the state has brought a complaint, and unless there is some procedural maneuvering by the state, this committee, I believe, has to make a recommendation. And for me, a lot of this has to do with timing. As I look to my other committee members, it has to do with if Mr. Chinchilla, I'm just speaking for me, a lot of my concerns that I've expressed on the record, if Mr. Chinchilla would have completed probation, there's a little bit of time between now and the incident that showed his continued good behavior and his continued progress and his continue to put this incident behind him. It's a stronger recommendation for the committee to make to the state board. And so for me, it's much more an issue of timing. And that's where I'm at.
If I could, just to make sure that everyone's clear, this came on the radar because DPS sent a fingerprint clearance card suspension notification after the arrest in May of 2017. That's what opened the complaint in this case. He had a valid secondary cert at that time and a valid sub-cert. So the investigation was instigated at that time. As the investigation went on, then he filed his application to remove deficiencies, so they had a separate file, so we fold them together. But this was not brought to light because of his application. And it occurred during the time he was certified, too, which brings it more into the complaint angle. But we have to deal with the application. But it starts with the complaint.
Hearing officer.
Can I ask a question? I have a question about all that. When the complaint was filed, I was never notified of any complaint. I was never notified of any investigation until after I had already requested my certificate renewal. I was never. That was the first time I talked to Mr. White. Was immediately after I submitted my request for renewal, and about a week later, I followed up with the Department of Ed, and that's the first time I was ever told that there was any issue with getting my certificate.
Thank you,
That was, by the way, in December of 2017, 7 months after the incident.
Ms. Winders, would you like to speak to that?
To the time frame?
Yes.
Well, let me just say, due to caseloads, cases will be opened and they're worked in the order they're assigned. Some are given priority. The sex cases are given priority. So oftentimes what will happen is there will be an open case that nothing has been done on it other than getting evidence. So we haven't interviewed anyone, and a respondent will submit an application. Then it becomes 2 cases, and there's a 60-day time limit on it due to the application. So it would make sense that that would be about the time he would have been notified.
When you open a case, you do not notify a respondent?
Not immediately, no.
Okay.
Within 60 days is what you're saying?
No, for your application had a 60-day window once you submit it.
See.
Yeah.
Other comments by the committee before we turn to the findings of fact? Mr. Quario? Oh, I'm sorry. I thought you were leaning forward.
I would like.
Ms. Sneed.
One of the other things that is going through my head that I'd like to share with the committee and with the respondent is that everyone on this committee is, in their various roles in education, is well aware of the need for good teachers in Arizona. But I specifically remember during training that for this committee that we can't use that as criteria, and that was before, so that it isn't person specific. But I'd like to just remind committee members that that was part of the training for as badly as we know. And I hate to see a great teacher's talents go to waste, but we really can't use that either in your favor or against you, and we can't consider that.
Anyone else? All right. The state has presented findings of fact, conclusions of law, and recommendation, which the committee will now turn to. Is there a motion?
I'd like to make a motion that we accept the findings of fact, paragraphs 1 through 18 as written.
Is there a second?
Second.
It's been moved and seconded that the committee accept the findings of fact 1 through 18. All in favor? Or is there any discussion? I'm sorry. All in favor?
Aye.
Aye.
Opposed? The motion carries. I'm sorry, Mr. Craig.
Aye, sorry.
The motion carries. Let us turn to aggravating factors. Are there any aggravating factors the committee would like to add to the findings of fact? Hearing none.
I do.
I'm sorry.
I have one. Yeah. H, illegal conduct.
Are there any objections to adding illegal conduct to the aggravating factors?
No.
I would also like to consider B, multiple offenses.
Are there any objections to adding B, multiple offenses, to the number 19 aggravating factors?
I do object. I don't think it's multiple offenses. I think there was one offense in which there were multiple counts, and that matters to me. It's not. This is not repetitive behavior. This isn't one DUI followed by another DUI followed by another. This is one offense of which there was also brought charges of just driving on a suspended license. So I would.
All right, I'm going to take a vote on this since we don't have a consensus. Ms. Sneed, would you make a motion, please, to add B?
I'm willing to withdraw that.
All right, thank you. So as it stands, under aggravating factors, we have one aggravating factor, H, illegal conduct. Are there any additional aggravating factors? All right. I need a motion to accept number 19.
I so motion.
A second.
It's been moved and seconded that the committee adopt 19 aggravating factors to include H, illegal conduct. All in favor?
Aye.
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 Opposed? The motion carries. Let us turn to number 20, mitigating factors. Are there any mitigating factors the committee would like to add?
I'd like to add A, absence of prior disciplinary record.
Is there any objection to adding A, absence of prior discipline record?
No.
Okay. Any other mitigating factors?
I would submit full and free disclosure or cooperative attitude toward disciplinary agency.
Are there any objections to adding D, full and free disclosure or cooperative attitude toward disciplinary agency?
May I amend that, Hearing Officer Lee? Because I don't know if he was cooperative with the agency. I would full and free disclosure and cooperative attitude towards the disciplinary body. Could I change that from agency to body?
Certainly. Are there any objections to adding D, changing the last word agency to body?
No objection.
Are there any other mitigating factors from the committee?
I would like to include the letters of recommendation.
As other?
Yes.
And those are Respondent's Exhibit
1, 2, 3.
1.
Yeah.
There were 3 letters, I believe.
1.
Okay. Respondent Exhibit 1. Are there any objections to adding H, other letters of recommendation, which are Respondent's Exhibit 1? Okay. Any other mitigating factors?
I would like to submit the transcript of the proceedings from Honorable Judge Jeffrey Papador, and I believe that's Respondent's Exhibit 3.
Okay. All right. Is there any objection to adding under H, transcript of Judge?
Is that like similar to the letters of recommendation?
Jeffrey Papador, it's in addition to Respondent's Exhibit 3.
Yeah.
Is there any objection to adding that?
Is it similar to like letters of recommendation?
Yeah, I would take this transcript of the judge. For me, it speaks favorably to how the respondent is conducting himself and states things that I think are pertinent to this situation, which is the respondent's not a criminal. The respondent hopes that this will not result in preventing the respondent from teaching. And I think that's worth putting in the record for the third time.
I'm sorry, Mr. Correa, was that an objection?
No, just clarification.
Thank you. Is there any objection to adding another H, transcript of Judge Papador, Respondent Exhibit 3? D, full and free disclosure or cooperative attitude toward disciplinary body. H, other letters of recommendation, Respondent's Exhibit 1. H, transcript of Judge Papador, Respondent Exhibit 3.
So moved.
Is there a second?
Second.
It's been moved and seconded that we approve mitigating factors A, D, and 2 H's. All in favor?
Aye.
Aye.
Opposed? The motion carries. Okay, conclusions of law on page 5 of the state's proffered document.
I make a motion for the PPAC to approve conclusions of law 1 through 15.
Second.
It's been moved and seconded that the committee adopt conclusions of law 1 through 15. All in favor?
Aye.
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 Opposed? Motion carries. We are now ready to discuss the recommendation. Is there a motion or any discussion before we take the motion?
Hearing Officer Lee, I would like to note that the proposed findings of fact, conclusions of law, and recommendation uses the language on, if you look at paragraph 2, about granting and or denying an application. It's not the general, or maybe it is. It's the. I apologize. We've got in 1, it's the disciplinary language, and 2, the grant or deny. And just to make sure I am clear, if we deny the certification, it is a 6-year suspension before he can, or a 6-year time frame before the respondent can apply again.
Not necessarily.
No.
We can put.
I think it's up
We
to
put a stipulation.
Can we
You
stipulate?
can suspend
because
the certificate any length of time up to 5 years. Suspend the certificate and impose conditions, any type of condition.
Perhaps, Mr. Sampson, they changed the law
happens all the time.
because it used to be if you have an application denied because of unprofessional conduct, you couldn't apply for 5 years. That was changed, and that's what I included in my opening statement, the reminder, because anyway, now if an application is denied, the board also determines what period of time the person can't submit an application, a period up to 5 years. So it's discretionary now. So we can say apply and you can't, or denied and you can't apply for 1 year, 3 years, 5 years.
That's perfect. Thank you for that clarification, and I should have known that.
Can I also have clarification as well?
Certainly.
So I understood that the respondent said that he is eligible, to, as part of his probation terms, that to apply to remove the felony, right? He's eligible to remove the felony and potentially make it a misdemeanor.
In 18 months, he said.
In 18 months, but with credit of, I think, 7 months. So roughly a year, 11 months. So I'm just wondering, has anybody done the math in terms of when, or is that something that we could stipulate in the suspension, pending his approval for his charges being reduced from felony to misdemeanor?
There was a date that was given in terms of the 3-year probationary period, which was November 3rd, 2020.
Yes.
Which is later than the potential for
That's
the
correct.
removal of the felony.
That's correct.
Mr. Chinchilla, I'm going to ask you, do you have a date that you have been told that you could possibly have that undesignated felony reduced to a misdemeanor?
No.
The court indicated to me that 18 months from the sentencing is the earliest that I can apply. And my probation officer also stated that as long as I'm in compliance with what's going with probation, that there would be very little reason to think that it wouldn't be approved at that point.
At 18 months.
At 18 months.
Rather than 3 years.
Yes.
So that would be May.
I believe that the probation started November 3rd, 2017. So it's 18 months from then.
That would be May 3rd, 2019 then, correct?
I don't have the calendar in front of me, so I apologize.
That would be my calculation.
Yeah.
What did you say, Mr. Kreider?
I said if it starts November 3rd of 2017,
Yes.
18 months would be May 3rd of 2019. Okay.
Yes, that's correct.
Okay.
Is there a motion on the recommendation?
I have one more clarification, sorry. Is this a motion against the application, or is this a motion against the...
Let's take them one at a
Okay,
time.
all right.
Mr.
Okay.
Kreider, thank you for the clarification question. So we're looking at number 1, recommendation.
I'll make a motion. Based on the findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through suspension through November 3rd, 2020 of any and all respondents' teaching certificates, and that all states and territories be so notified.
Is there a second?
Second.
The motion is based on the findings of fact and conclusions of law above. The PPAC recommends that the board take disciplinary action through suspension of the certificate through November 3rd, 2020 of any and all respondents' teaching certificates, and that all states and territories be so notified. Is there any discussion? Kellen, will you call the roll?
Wait a minute, I have one question. Is that the certificate and the that's all certificates?
Yeah,
okay.
it's
Okay. Okay.
Chair Sampson?
No.
Member Correa? Oh.
Yes. Oh.
I'm sorry, I believe Mr. Sampson has to explain a no vote.
I do. And I'll take that opportunity and I'll try and be brief. I don't believe that given the mitigating circumstances that we are looking at, that this is the appropriate action to take with this individual educator. By suspending his substitute certificate, you are essentially removing him from the profession for 3 years. And I understand the actions were very serious. I do, however, believe they're isolated, and I do believe that they're unlikely to happen again. I also understand how concerning it is given the nature of the offense. But I simply do not believe that suspending his certificates and taking his opportunity to teach away for 3 years serves anything but additional unnecessary punishment for something that he is already serving time for. So with that, I vote no. Thank you. Thank you.
Sorry, Kellen, continue.
Member Correa?
Yes.
Member Kreider?
No.
Member Sadorf?
Mr. Kreider needs to explain his vote.
My rationale goes back with what I wanted clarified earlier is the difference between his certificate, his teaching certificate, and a sub-certificate. I think that the punishment has already started, and I believe it's an it's a one-time isolated incident. I understand that the severity of it. I understand that I'm attaching my name to a no here. So, but I just feel that the punishment is a little bit too severe for it being albeit a severe lack of judgment, just too severe for what it turned out to be.
Thank you, Mr. Kreider. Kellen, please continue.
Member Sador?
Aye.
Member Sneed?
I'm going to vote no. And to explain my feeling, I do think that some disciplinary action should be taken. I am not comfortable with having someone in the classroom with a felony. However, if in May of 2019, which is just around a year from now, that felony would be reduced to a misdemeanor, I would vote against any disciplinary action because I think that Mr. Chinchilla is an asset to the classroom, and I think he's in earnest, and so I have to vote no because of the severity of the motion.
And you have 3 noes, 2 yeses.
The motion fails. All right. The committee may suspend the certificate and impose conditions. So maybe we are there with a new motion. Or we can go back to suspend the certificate for any length of time up to 5 years.
Are you thinking about, if I may?
Certainly.
Are you thinking about having him come back after the felony has been removed? So after May 3rd, 2019? Is that?
Well, yeah, I would place it on the respondent in this case and say we suspend the certificate until such time as the felony has been reduced to a misdemeanor.
So with a condition?
Yeah, with the condition. And then if it takes 3 months, great. If it takes 2 years, it's on him working with his probation officer in the court. And that way we don't impose the investigative unit or the state board the responsibility to monitor this. We put it in the hands of the applicant to work with his probation officer and the legal system to take care of that.
I'm fine with that, if you want to make that motion.
Sure, I can't ever do it again. You know that. You've worked with me for a long time. I move that we suspend the applicant's standard substitute certificate until such time as the applicant is able to reduce the felony to make this motion, I got to get it right. Strike that, please, Angela. Don't make me look more foolish than I already do. Where's? Apologize.
What are you looking for?
I am looking for what he pled to. Does anybody have that? Because I want to get the language correct.
It's a Class 6.
I'm sorry, could I make a recommendation? Just could you possibly do a minimal time frame, like maybe come up with the 18-month date or until he satisfies that requirement? So we can enter a date in the databases for his suspension length?
Database. Yeah, 1 week or until. No, I'll make something. It's a Class 6 undesignated felony. Is that correct?
That's correct.
Okay. Okay. I move that the respondent's substitute teaching certificates be suspended for a minimum of 3 months and or such time as the reduction of his Class 6 undesignated felony is reduced to a misdemeanor. Did I get that correct?
Can I ask a clarifying question?
Or make it better? Yes.
Why 3 months?
I
So they have something to
They
put in the
have to
database.
put a date in the database. If you, I can make it 6.
The actual date?
He might be able to work with his probation officer to move it quickly, so I'll acknowledge that. But it can be 6. And to get you on my motion, I'm willing to do that.
I have a question on your motion. I believe you said substitute certificate. Did you also mean the standard certificate?
Well, his standard is the next. This is only motion 1 we're getting to.
Okay.
So
I'm sorry, I misunderstood.
No, I because I believe we got to deny his application. Mr. Schwartz is.
Any and all.
Yeah.
It's any and all?
Any and all.
Okay, then I will do any and all certificates for a minimum of 3 months or such time as. That doesn't make sense. Because that means, that means he could apply in 3 months' time.
Right.
So let me do this. I move that the respondents, any and all certificates by respondents be suspended until the earlier of the removal of his undesignated Class 6 felony to a misdemeanor or 18 months.
Which is May 3rd, 2019.
Which is May 3rd, 2019. Does that make sense, and does it satisfy all requirements?
18 months isn't May 3rd.
Or 2020?
May
2019.
That would be a year from now.
18 months is May 3rd, 2019, from the imposition of sentencing.
Which is the earliest he can apply.
That's the earliest he can apply.
That's the earliest he
for
can
the,
Right.
for the removal of the felony.
Right.
So it's May 3rd.
All right, I'm going to try and restate this.
And
I'll
if you can make
probably
it better, please, and then I will move on it.
I will need all the help I can get.
And I'm sorry, before
Schwartz?
you read that, I was wondering if anybody thought about, we do have the possibility of the felony being redesignated as a misdemeanor, but there's also a 3-year probation out there. Now that could be ended early. Now I don't know if the two go hand in hand, that if it gets redesignated to a Class 1 misdemeanor, they end probation that day, or if probation continues. There's a 3-year probation right now that I was wondering if anybody was thinking about that.
Hence my first motion.
Yeah, we've gone down that road.
Mr. Chinchilla, would you like to comment since you have
so
more knowledge on this?
I do. So at the end of 18 months, I can request that probation be completed. At the end of the completion, then I can request for the undesignated to be designated a misdemeanor. So all of that can happen in 18 months.
All right, the motion is based on the findings of fact and conclusions of law. The PPAC recommends that the board take disciplinary action through suspension of any and all of respondents' teaching certificates upon the earlier of the removal of a Class 6 felony to a misdemeanor or 18 months, May 3rd, 2019. Is there a second? Or is there a better statement?
No, so moved.
18 months from the sentencing date of November 3rd, 2017.
Okay, a couple of things. Removal, is removal the correct word or reduction?
Reclassification.
Reclassification.
Or redesignation, I'm sorry, because it's a Class 6 undesignated felony.
Right, okay.
So it would be designated, I'm sorry.
Word.
Redesignation from a Class 6 felony to a misdemeanor. Is that what you mean, Ms. Need?
Yes.
Thank you.
And the May 3rd date is only a year from now. So he can request it at that point in time, but that doesn't mean it would be all finalized in that point of time.
That's right.
Correct, but I believe the either-or condition, and correct me if I'm wrong, Mr. Sampson, that it's whatever occurs first.
Earlier.
Okay, let me try this again. Based on the findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through the suspension of respondents, suspension of any and all of respondents' teaching certificates, and that all states and territories be notified upon the earlier of a redesignation of the class 6 felony to a misdemeanor, or 18 months, May 3rd, 2019.
So moved.
Is there a second?
I'm sorry, I need clarification, and I'm sorry to drag this out. Do we want to say upon or until?
Right now it's upon the earlier of.
I accept the amendment of mine.
Okay.
Until the earlier of.
Until the earlier, and then we need a verb, I believe, until the earlier
of
the redesignation of a class 6 felony to a misdemeanor, or
May 3rd.
18. Should we just do May 3rd instead of the 18 months?
Yeah.
Okay.
I'm sorry to butt in again, but when you say the earlier of, so if he screws up and it doesn't get redesignated and then May 3rd comes, that's earlier and it hasn't been redesignated, so it would be through May 3rd of 2019, correct?
Good point, Mr. Schwartz.
So.
The redesignation must be a condition.
Yeah.
The date is May 3rd, 2019. That's 18 months. It's the earliest that he's able to do that. The condition must be that the felony is redesignated to a misdemeanor.
Yes, I agree. I was just trying to put in a date so they could work in their computer system, which I understand is super important. So I'm the one that created this mess. Let me try again, Officer Lee, to say, I just voted for your motion, but okay.
Are you withdrawing the motion?
I am withdrawing the motion if I'm allowed to make another motion.
Absolutely.
Mr. Lee. Based on the findings of fact and conclusions of law, I move that the respondents, any and all teaching certificates, respondents, any and all teaching certificates of the respondents.
Well, you had a date of.
But it had a date of November 3rd, 2020, because his probation is
through that
3 years.
But based on what he said, if he complete probation up to 18 months earlier. So if we just remove the date and make the office deal with the thing, I think I'm happy to support that motion again. Okay. My issue was the date.
Gotcha.
It was that you had to be. It was 3 years,
gotcha.
As opposed to he gets it cleaned up. The earliest is, and he's done.
Is there a second?
I just wanted to make the motion.
Do we have a motion?
We need a second for the motion. Ms. Williams.
Hearing Officer Lee, members of the PPAC committee, I was watching on the video stream and
shot
over here.
You to come over.
So it is very imperative that the investigative unit, as well as the department, or the investigative unit, as well as the State Board of Education, has an end date for that suspension, because we do. If the board is to take your recommendation, it is reported to the national NASDAQ, and we need to have an end date. I would recommend stating an end date, and then if the respondent finishes the conditions prior to that end date, and then he can have a conversation with the investigative unit and board staff.
How about this? No sooner than May 3rd, 2019. Does that get to where we need to go?
Can I ask a question? If we had a motion for November 3rd, 2020, with the condition that if all probation requirements have been met and the felony has been redesignated to a misdemeanor, would that satisfy that end date?
Hearing Officer Lee, member Sadorf, that would.
Okay, then I will make a motion.
Second.
Are you going to withdraw your motion?
Well, there's already a motion on the. There's already a motion.
Okay. I'd like to make a motion based on the findings of fact and conclusions of law. The PPAC recommends that the board take disciplinary action through suspension of any and all of the respondents' teaching certificates through November 3rd, 2020, with the condition that if any and all probationary terms have been met and the Class 6 undesignated felony has been reclassified, redesignated as a misdemeanor, that he be allowed to, at that point, come back to the PPAC. And that all states and territories be so notified.
Is there a second?
Second.
I'm not reading. I can't read it back. All right. It's been moved and seconded that
motion on the table.
Go with it.
That basically, I'm not going to repeat the exact motion, but I'll give the gist that the board take disciplinary action through suspension and any and all respondents' teaching certificates in all states territories be so notified through November 30th, 2020. November 3rd, 2020, unless
With condition?
with the condition that the undesignated Class 6 undesignated felony be restored to a misdemeanor, and all probation requirements be met, and that the respondent can come back and apply to the PPAC for his teaching certificate. And that's a pretty bad rendition of your motion. Kellen, will you call the roll?
Member Correa?
Aye.
Member Kreider?
Aye.
Member Sadorf?
Aye.
Member Sneed?
Aye.
Chair Sampson?
Aye.
All ayes.
Unanimous vote. The motion carries. And we have number 2 to consider.
I think
We just
gathered
we
everything.
put it into one.
Any and all.
Thank you. Okay. This concludes the formal hearing. The committee's decision will be reduced to a written...
Wait, excuse me. Now you need to address whether to grant or deny the application.
The committee just decided that they did that in the first motion.
Based on what I understood you to tell me, which is that, because I was trying to bifurcate that originally, Mr. Schwartz, between the certificates and suspending the certificates and the application process. He said everything was rolled up into that one. So,
well, I didn't say it like that at all. But anyway, the way these go,
I misunderstand things all the time, counsel. But I don't think I'm the only one with that impression.
When
so,
these hearings are we have a complaint and application. You do the hearing. If you find unprofessional conduct, you deal with the complaint aspect first. And you say we're going to impose discipline through whatever, a 2-year suspension. Then you go to the application and you vote to grant or deny. And if you vote to deny that application, then you decide what period of time they can't apply.
Ms. Williams, could you weigh in on this? Have we satisfied both issues with that motion?
Hearing Officer Lee, members of the committee, no, you have not satisfied. The board, because this is a complaint and an application, would need to know whether or not this committee would like to deny or approve the application for certification. If the committee chooses to deny the application, then there will need to be a time frame associated. Typically, historically, the PPACs have recommended to the state board when they suspend a certificate and deny an application the same time frame. That way it's easier for both board staff and the department staff to enter that into the record.
And Ms. Williams, this occurred because Mr. Chinchilla asked to remove a deficiency. Is that correct?
That is correct, Hearing Officer Lee.
And could this be solved if Mr. Chinchilla withdraws that request?
That is correct, Hearing Officer Lee.
Could I hear the committee on that?
I'd be happy. I mean, I don't think the committee can accept the withdrawals, but if applicant's willing to do that, we don't have to take a motion on that.
That seemed like it would end a lot of the complication that's going on right now. So I would say, yeah, I don't have an issue withdrawing, considering especially that I imagine it's going to be denied either way. So if withdrawing it will save me some paperwork down the road when I try to reapply, I definitely am in favor of that.
You will eventually have to apply for the deficiency removal again.
I see.
All right, we'll let you work that out between yourself and the department.
I see.
Or State Board of Education. All right, as I was saying, this concludes the formal hearing. The committee's decision will be reduced to a written recommendation and delivered to the Board of Education. The board will make the final decision. Each party will receive notice of the board meeting at which it will consider the committee's recommendations. The parties will have further appeal rights. So let's take a 5-minute break. Thank you. Mr. Schwartz, we don't know what case is next.
Why don't we do Natsumi?
Thank you. So we will start Mr. Natsumi's case at 10:38. Thank you, everyone.
Thank you.
The Professional Practices and Advisory Committee calls the next case Arizona State Board of Education v. Hajime Natsumi, case number C-2017-296. My name is Prudence Lee. Today, May 8th at 9 a.m. was the date and time set for the disciplinary hearing for Hajime Natsumi. It is actually 10:47 a.m. This is set forth in the complaint and notice of hearing. Present to hear the testimony and for deliberation and decision are members of the Arizona State Board of Education Professional Practices Advisory Committee. Kellen, please call the roll.
Chairman Sampson?
Present.
Member Correa?
Present.
Member Kreider?
Present.
Member Harris? Member Sadorf?
Present.
Member Sneed?
Present.
You have a quorum.
Thank you, Kellen. This hearing is held in accordance with Arizona Revised Statutes 15-203 and Arizona Administrative Code R7-2-701 at SEC. I am the hearing officer designated by the State Board of Education Executive Director to conduct the hearing in this disciplinary matter. This hearing is being recorded by a court reporter and video recorded. Therefore, only one person should speak at a time, and anyone speaking needs to speak up so that the microphone will pick up what is said. Would all other persons identify yourself for the record?
Garnett Winders, Chief Investigator, Department of Education.
White, Director of Special Projects, State Board of Education.
Eric Schwartz, Assistant Attorney General on behalf of the state.
Kellen Wesley, Executive Assistant, State Board of Education.
Thank you. The respondent is not here for the hearing. Mr. White, how was respondent served with a notice of hearing?
Hearing Officer Lee, pursuant to statute, respondent was sent notice of meeting via certified mail.
Thank you. And was that mail picked up?
It appears it was delivered. It says addressee unknown, so it looks like it's in transit to be returned to our office.
Thank you. The state will proceed with opening statements. It's optional. Then the state will present evidence because the state has the burden of proof in this matter. The hearing officer reserves the right to ask questions. Committee members may also ask questions. Do you have witnesses today, Mr. Schwartz?
I'll call one.
All right, thank you. At the conclusion of the hearing, the committee will deliberate and decide whether to dismiss the case or take appropriate disciplinary action. The state must prove its case by a preponderance of the evidence, which means it is more likely than not that the facts occurred as asserted by the state. In an administrative hearing such as this, the formal rules of evidence do not apply, and hearsay is admissible. Parties may object to evidence on certain narrow bases, such as relevance. Are there any preliminary matters, Mr. Schwartz?
Regarding exhibits, I'd ask that exhibits 1 through 13 that were submitted along with the complaint be admitted into evidence, and that the notice of hearing and the USPS tracking be marked as Exhibit 14 and admitted in evidence.
The notice of hearing and the USPS tracking notice is marked as Exhibit 14. Exhibits 1 through 14 are admitted into evidence. Anything else, Mr. Schwartz?
I'd ask that the proposed recommended decision that I pass out that the committee be marked as Document 1 and admitted into the record as Document 1.
The proposed findings of fact, conclusions of law, and recommendation are marked as Document 1 and are made part of the record. At this time, I will swear in your witness.
I'm sorry, it's my telephone.
Thank you. I will not until we get there. Okay. Do you have an opening statement, Mr. Schwartz?
I do.
Thank you.
Okay. Members of the committee, the evidence will show that Hajime Natsumi was originally reported for unprofessional conduct by Ace Charter High School in February of 2017 after Mr. Natsumi made inappropriate comments to his high school students about going to the gym and working out his eyes by staring at men's private parts. Mr. Natsumi was terminated by Ace effective February 22, 2017 because of those inappropriate comments. However, as the investigation into Mr. Natsumi's conduct progressed, more evidence was gathered which establishes that Mr. Natsumi also provided false information on applications for employment with at least 2 different schools, which only compounds the discipline Mr. Natsumi should be facing now. Prior to working as a teacher at Ace Charter High School, Mr. Natsumi had been employed as a teacher by the Globe Unified School District from November of 2014 until June of 2015. His brief employment with Globe was rocky, to say the least, and apparently he did not want any future employers to know about his employment with Globe. Therefore, on his January 18, 2017 application for employment with Ace, Mr. Natsumi provided false information by failing to disclose his employment with Globe in the work experience section of that application. Additionally, after he was terminated by Ace on February 22, 2017, Mr. Natsumi submitted an application for employment as a teacher to the Colorado River Union High School District on April 12, 2017, less than 2 months later. On that application with Colorado River, Mr. Natsumi falsified or misrepresented information in several ways. First, he once again failed to disclose his employment with Globe, this time in the employment history section of that Colorado River application. Second, he also failed to disclose his employment with Ace Charter High School on the same application. And third, he answered no to a question on that application about whether he'd ever been terminated, despite the fact that he'd been terminated by Ace less than 2 months earlier. The evidence will show that Mr. Natsumi engaged in unprofessional conduct pursuant to Code Section 1308A1, which states that certificate holders shall make reasonable efforts to protect pupils from conditions harmful to learning, health, or safety. Additionally, Arizona Revised Statutes Section 15-512N states, quote, a person who makes a false statement, representation, or certification in any application for employment with the school district is guilty of a Class 3 misdemeanor. The evidence will show that Mr. Natsumi violated the provisions of ARS 15-512N. Furthermore, that same conduct constitutes unprofessional conduct pursuant to Code Section 1308B6, which states that certificate holders shall not falsify or misrepresent documents, records, or facts related to professional qualifications or educational history or character. Finally, all of the conduct and circumstances described above constitute unprofessional conduct pursuant to Code Section 1308B15, which states that certificate holders shall not engage in conduct which discredits the teaching profession. Mr. Natsumi's inappropriate comments of a sexual nature to students and his repeated actions of providing false information on employment applications certainly discredit the teaching profession. For the foregoing reasons, the state requests that the PPAC recommend to the board that it take disciplinary action through revocation of any and all of Mr. Natsumi's teaching certificates. Thank you.
Thank you. Please call your first witness.
Jay Slaughter.
Hi, is Jay Slaughter? Yeah, this is Colin with the State Board of Education. Okay. Hi, Mr. Slaughter. This is Colin with the State Board of Education. Yeah, I'll conference you and you'll be able to hear them a little better on the open speakers here. Okay, just a minute. Hearing Officer Lee, Mr. Slaughter's on the line.
Mr. Slaughter?
Yes.
Hi, my name is Prudence Lee. I'm the hearing officer assigned to this matter today. Would you please raise your right hand?
Yes.
Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
I do.
Thank you. Mr. Schwartz, the Assistant Attorney General, will now ask you questions.
Okay, thank you. Yes, Mr. Slaughter, could you please state and spell your name for the record?
Yes. J-A-Y, Slaughter, S-L-A-U-T-E-R.
And where do you work?
I work at Tucson Youth Development in Tucson.
And what's your job title there?
I'm Executive Director of the organization and also Superintendent of the educational aspect of the organization.
Okay, and how long have you been there in that job?
Well, I've been in this job for 2.5 years, came into this position in August of 2015, but I've been with the organization for nearly 15 years.
Okay, and could you help explain for the committee what Tucson Youth Development is, its relation to ACE Charter High School, et cetera, just so everyone understands what we're dealing with?
Yes. Tucson Youth Development is the 501c3 nonprofit organization that is the charter holder for ACE and YouthWorks Charter High Schools. Tucson Youth Development applied to open the charter and was granted the charter in 1996, one of the first 53 schools chartered in Arizona.
Okay, thank you. So ACE Charter High School is a public charter high school here in Arizona?
Yes, it is.
Okay. And are you familiar with a man named Hajime Natsumi?
Yes, I am.
And how do you know him?
He applied to work at ACE Charter High School last year, and I think he applied in January of 2017, and we did hire him to be a math teacher.
Okay. And do you have a copy of the exhibits in front of you that were sent to you prior to the hearing?
I do.
Okay, I think we had exhibits 1 through 13, I think.
Let's see.
Yeah.
Yeah, I think I have exhibits. Yeah, 1 through 13.
Okay, great. Could you please look at Exhibit 6, pages 40 to 42? They have page numbers in the upper right corner. That's usually the easiest way to get to pages. So 40 to 42.
Okay, I have it.
Okay. Is that the application for employment that Mr. Natsumi submitted to Tucson Youth Development that you just described?
Yes, it is.
Okay. And so this was an application basically for employment as a teacher at ACE Charter High School?
Yes, it is.
Okay. And if you look at page 41, there's a section entitled Work Experience. It says, please list all previous employment beginning with the most recent. If you need more room, you may attach another sheet of paper. Does it appear as though Mr. Natsumi disclosed any employment with Globe Unified School District where he worked from November of 2014 through June of 2015?
I do not see Globe listed on here.
Okay. No. And so was Mr. Natsumi hired as a teacher at ACE Charter High School based on this application? And then I assume an interview, but based on this application in part?
Based in part on this application, yes. Yeah, we did also interview him, although I was not involved in the interview.
Sure. Okay. And then Exhibit 7, page 44 to 48, is that the teacher employment contract that was given to Mr. Natsumi for that, looks like January 24 of 2017 for the balance of the school year?
Yes, it is.
Okay. In February 2017, did you or anyone in administration receive any reports of inappropriate comments that Mr. Natsumi had made to some of his ACE charter high school students?
Yes, we did. I don't know, I can't remember exactly who the report was first made to, but it was brought to my attention, yes.
Okay, and once it was brought to your attention, what steps did you take or did the school take?
Well, yeah, we essentially I convened a meeting with the site principal, who Mr. Natsumi was working under the supervision of, he collected some records, I guess you could say, from students who had made statements, put those into written form, and then myself and the site principal and our human resources officer interviewed Mr. Natsumi regarding the allegations.
Okay. Let's talk about real quick then on page 58. It's in Exhibit 8. If you're there, is this notes that were taken of the interview you just described, where it looks like you and is Arturo Menchaca, was that the principal at ACE at the time?
Yes, he was.
And Dania Rubio, who is she?
Yes, Danita Rubio was our human resources officer and still is.
Okay, so are these the notes that were taken of the interview with Mr. Natsumi?
Yes, they are.
Okay, and best your knowledge and recollection, are these notes accurate?
They are.
Okay. I'll take you through just a few other of these pages. Well, looks like pages 52 through 56 are handwritten statements. Were those handwritten statements submitted by ACE students of Mr. Natsumi?
They were, yes, they are, and they were submitted by students who were in his class or classes. Okay,
and they describe various instances of interactions with Mr. Natsumi, including the comments about going to the gym and working out his eyes by looking at men's private parts.
Yes.
Okay, and then page 57, are those... look like maybe were those notes of an interview of another student?
Yes, those are notes of an interview. I was not involved in this. This was done by the site principal and the human resources officer, and so I was not involved, but I did receive a copy of this record.
Okay, so once you had collected statements, or the school collected statements, interviewed students, interviewed Mr. Natsumi, what decision did you make regarding his employment?
Before we did all of that, as soon as the allegations were made, we put him, as soon as we received some description of the allegations, we put him on paid leave, and then on, looks like more, I'm looking at one of your documents here. Let's see. I sent an email letter to Mr. Natsumi on February 21st, notifying him that his employment with Tucson Youth Development and ACE Charter High School was being terminated effective February 22nd.
Okay, that's page 51 there?
Yes, that's page 51 of the evidence.
Okay, and in that letter it says, yesterday we discussed the comments your students reported you made in your math class on Friday, February 17, 2017. Your comments were sufficient cause for me to terminate you. So that's the comments about in the shower?
Yes.
Okay. Okay, so again, on page 51 is the email. That's your notification to Mr. Natsumi that his employment was terminated by Tucson Youth Development / ACE Charter High School, correct?
That's correct.
Okay. Is there any other testimony you'd like to offer today regarding Mr. Natsumi that you think might help the committee in their deliberations?
Well, I hadn't really thought about testimony. Only I would like to say, I guess, that this teacher was only really with us a short period of time, and it became so just barely a month, actually, that he was actually teaching. And we did have, these statements were made by students that were in his class, and it was not only the inappropriate statements that he made regarding the
phone.
You're very welcome.
You are excused. Thank you.
Thank you.
Any other witnesses, Mr. Schwartz?
No, I had witnesses from Globe and Colorado River I could call, but they're not necessary. They were just going to authenticate their documents, so I rest.
All right. Would you like to proceed with closing argument?
Sure. Again, it would just be similar to my opening. We just heard, unrefuted testimony here and evidence in the records unrefuted about his inappropriate comments to students during his brief time with Ace Charter High School. But additionally, as is set forth in the record, Mr. Natsumi apparently doesn't last anywhere very long, which is always red flags. And then he doesn't let subsequent districts know where he's been so they can check him out. So he falsified different applications by not disclosing that he worked at Globe when he applied with Ace Charter High School. And then when he applied 2 months after being fired by Ace, he applies to Colorado River, and he doesn't disclose that he'd worked at Globe or that he'd worked at Ace. And there's even a question about have you ever been terminated, and he said no. So he was only he was at Globe probably the longest time out of these 3 schools, and he was there about 5 months, and then less than a month at Ace, and I think about a month or not very long at Colorado River. But anyway, the evidence just clearly establishes unprofessional conduct on any number of grounds, and the recommendation would be revocation of any and all certificates held by Mr. Natsumi. Thank you.
Thank you, Mr. Schwartz. Having heard the testimony and reviewed the evidence, the committee will now discuss the case. Is there any discussion prior to proceeding to the proposed findings of fact, conclusions of law, and recommendation? All right. Let's turn to the findings of fact. Is there a motion on the findings of fact?
I'll make a motion that the PPAC accept the findings of fact. Paragraphs 1 through 18 is listed.
Is there a second?
Second.
It's been moved and seconded that the committee adopt findings of facts 1 through 18. All in favor?
Aye.
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 Opposed? The motion carries. Let us turn to number 19, aggravating factors. Are there any aggravating factors the committee would like to add to the findings of fact?
I'd like to include B, multiple offenses.
Are there any objections to including B, multiple offenses? Hearing none, they will be added. Are there any other aggravating factors the committee would like to add?
I'd like to throw it out there to the committee for their opinion. Refusal to acknowledge wrongful nature of conduct in terms of the interactions between him and some of the administrators that were working with him. It appears that there was a refusal on his part to acknowledge that he had parts of.
Are there any objections to adding E, refusal to acknowledge wrongful nature of conduct?
No.
Okay. Any other aggravating factors?
Failure to show this hearing.
Under other?
Aye.
Under other, failure to show at this hearing?
Would that be part of E? I'm not like contradicting. I'm just, was that part of E?
Yeah.
Okay.
It's assumed by E.
All right, then we'll, you are withdrawing. Thank you. Thank you. Any other aggravating factors? Okay, any mitigating factors? Hearing none, the committee will not add mitigating factors. May I have a motion on adding the 2 aggravating factors, B and E?
I saw motion.
Second.
Thank you. It's been moved and seconded that committee adopt aggravating factors B, multiple offenses, and E, refusal to acknowledge wrongful nature of conduct. All in favor?
Aye.
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 The motion carries. That takes us to the conclusions of law. Is there a motion?
Make a motion that the PPAC approve conclusions of the law 1 through 20 as presented.
Is there a second?
Second.
It's been moved and seconded that the committee approve conclusions 1 through 20. All in favor?
Aye.
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 Opposed? The motion carries. We turn now to the recommendation. The committee may consider any of the following actions alone or in combination pursuant to ARS Section 15-203A2. Issue a letter of censure, suspend the certificate for any length of time up to 5 years. 3, suspend the certificate and impose conditions, any type of condition. 4, revocation.
I move that based on the findings of fact and conclusions of law above, the PPAC recommend the board take disciplinary action through revoking any and all of respondents' teaching certificates in all states and territories. Be so notified.
Second.
It's been moved and seconded that based on the findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through revoking any and all of respondents' teaching certificates and that all states and territories be so notified. Kellen, would you call the roll?
Member Correa?
Aye.
Member Kreider?
Aye.
Member Sadorf?
Aye.
Member Sneed?
Aye.
Chairman Sampson?
Aye.
All ayes.
By your vote of 5-0, you have made the recommendation to revoke the teaching certificates of Mr. Hajime Natsumi. This concludes the formal hearing. The committee's decision will be reduced to a written recommendation delivered to the Board of Education. The board will make the final decision. Each party will receive notice of the board meeting at which it will consider the committee's recommendations. The parties will have further appeal rights that will be explained at the final order issued by the Board of Education. This concludes this hearing. Mr. Schwartz, are you prepared to proceed with the next case?
Well, I am, and I need 5 minutes to
Okay, we'll stand in recess
move my papers.
until 11:19. Longer break right now? Okay. Thank you, Mr. Corio. I'm not on. Mr. Schwartz. Calls the case of Arizona State Board of Education v. Sonia Williams Rowe, case number C2016-188. My name is Prudence Lee. Today, May 8th at 9 o'clock was the date and time set for the disciplinary hearing for Sonia Williams Rowe. It is actually 11:24 a.m. This case is set forth in the complaint and notice of hearing. Present to hear the testimony and for deliberation and decision are members of the Arizona State Board of Education Professional Practices Advisory Committee. Kellen, please call the roll.
Chairman Sampson.
Present.
Member Correa.
Present.
Member Kreider.
Present.
Member Harris. Member Sadorf.
Present.
Member Sneed.
Present.
You have a quorum.
Thank you, Kellen. This hearing is held in accordance with Arizona Revised Statutes 15-203 and Arizona Administrative Code R7-2-71 et sec. I am the hearing officer designated by the State Board of Education Executive Director to conduct the hearing in this disciplinary matter. This hearing is being recorded by a court reporter and video recorded. Therefore, only one person should speak at a time, and anyone speaking needs to speak up so that the microphone will pick up what is said. Would all other persons please identify yourself for the record?
Garnett Winters, Chief Investigator, Department of Education.
Soyika White, Director of Special Projects, State Board of Education.
Eric Schwartz, Assistant Attorney General on behalf of the state.
Kellen Wesley, Executive Assistant, State Board of Education.
Thank you. The respondent has not appeared for this hearing. Mr. White, how was respondent served with a notice of hearing?
Hearing Officer Lee, the respondent was served notice of hearing via certified mail, and it appears that it is still available for pickup. It was not picked up.
Thank you. The hearing will consist of opening statements, which may be waived. The state has the burden of proof, which means it is more likely than not that the acts occurred as asserted by the state. The hearing officer reserves the right to ask questions of the witnesses. Committee members may also ask questions of the witnesses. At the conclusion of the hearing, the committee will deliberate and decide whether to dismiss the case or take appropriate disciplinary action. Hearsay is admissible. The rules of evidence do not apply. Are there any preliminary matters, Mr. Schwartz?
Yes, I'd ask that Exhibits 1 through 9 that were submitted along with the complaint be admitted into evidence, and that the notice of hearing and the USPS tracking sheet for Ms. Williams Rowe be marked as Exhibit 10 and admitted into evidence.
The notice of hearing and UPS tracking, United States Postal Service tracking sheet will be identified as Exhibit 10, and Exhibits 1 through 10 are admitted into evidence. And do you have any witnesses today?
I have several. And also, I'd ask that the proposed findings of fact be admitted or marked as Document 1 and admitted into the record.
The proffered findings of fact, conclusions of law, and recommendation is marked as Document Number 1 and made part of the record.
Hearing Officer Lee and Mr. Schwartz, I'm wondering, since the respondent didn't show, do we want to just stipulate to all of the facts that are in evidence and move forward? I'll defer to you.
I'd prefer to put on testimony. I certainly plan on doing it in a much more truncated fashion than I would have otherwise, but I've got people who've been working with me for a long time to do that, and some actually are really eager to. So, but I will certainly make it. Sorry.
I apologize. Hearing Officer Lee, Mr. Schwartz, I don't want to be rude to any of the witnesses that you've created a relationship with. I was just, if there weren't, we could move pretty quickly through.
No, absolutely. Depending on the case, that could be an option. But I'd ask that we, I'll do it quickly. I promise.
Perfect.
All right. Would you like to waive opening statement, Mr. Schwartz?
Sure.
All right. Please proceed with your witnesses.
Okay. Can you call Marie Zawel? first three witnesses should be actually together, huddled in a room in Camp Verde.
Nice place to be.
Hi, Marie Zawal. Hello, this is. Okay. Okay, are you good now? Sure. Okay. Okay. Just let me know when you're ready, and then I'll bring you into the PA system here.
Hearing Officer Lee, it'll be just one moment. They're getting the other witness in the room.
Thank you, Kellen.
I understand. Okay, just one moment. I'm going to conference you in.
Hearing Officer Lee, the witnesses are on the line.
Ms. Zawel?
Yes.
Hi, my name is Prudence Lee. I'm the hearing officer assigned to this matter. Could you please raise your right hand?
Yes.
Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
Yes.
Mr. Schwartz, the Assistant Attorney General, will now ask you questions.
Okay, thank you. Good morning, Ms. Zawel.
Hello.
Hi, could you please state and spell your name for the record?
My name is Marie Zawel. It's spelled M-A-R-I-E. Last name Z-A-W-E-L.
And where do you work?
I work at South Verde High School, which is part of Camp Verde Unified School District.
And what's your job title there?
Currently, I am the English teacher for grades 9 through 12.
Okay. And in April of 2016, were you also the administrator of South Verde High School as well as the English teacher?
Yes, I was.
Okay. And are you familiar with a woman named Sonia Williams-Rowe?
Yes, I am.
And how do you know her?
She was my employee that year.
Okay, so she was a teacher at South Verde High School when you were the administrator there?
Yes, she was a special ed teacher, and she was also in charge of the lab, so she was the lead teacher in the lab.
Okay. Before we get into it, there's a term that shows up throughout the documents. It talks about schoolmaster. I just asked, could you explain what schoolmaster is, just so everybody understands?
Yes, Schoolmaster is a computer program that the entire district uses, and it's utilized for attendance, utilized for grades, transcript, health information, private information about the student as far as their parents, guardians, their addresses, shot records.
Okay, and is access to that schoolmaster system limited?
Yes, it is.
And did Ms. Rowe have authorization to access schoolmaster?
No.
Okay. Back on April 6th of 2006, well, first, do you have a copy of the exhibits that are being used in the hearing today, exhibits 1 through 9 that were sent to you prior to this hearing?
Yes, I do.
Okay, and did you have an opportunity to go through those exhibits prior to the hearing?
Yes.
Okay.
Yes, I did.
Okay, I'll just kind of cut to it. April 6, 2016, did you become aware of an incident that occurred in the lab at your school between Ms. Rowe, a student we've identified as student B, and Ms. Rowe accessing schoolmaster?
Am I aware of it?
Did you become aware of it there on April 6, 2016? Yes. And how did you become aware?
Miss Murphy, Dion Murphy, another employee of the school, came to me in my classroom and informed me that there had been an incident down in the lab.
Okay, and what did she tell you?
She told me that she witnessed Sonia Rowe at her computer down in the lab, and that the student B was speaking to Sonia and stated that she needed to lower her car insurance rates because as her GPA wasn't high enough. And Miss Murphy witnessed Sonia go on her computer and access Schoolmaster.
Okay. So what did you do once you were given this information as the administrator?
I immediately made a phone call to the superintendent of the school district, Dr. Goodwin, and I went to his office and spoke to him privately about the matter. Then he contacted Erin Moya, who was our technology director at the time, and he also contacted the district attorney to speak to him to get advice.
Okay. And so did Mr. Moya, the director of technology, investigate the computer system to see if Ms. Rowe had accessed Schoolmaster?
Yes, he did.
And did he bring his results to you?
Yes, he did.
And what were the results of his computer analysis?
The results were that Sonia had accessed Schoolmaster on April 6, 2016, and also that she had used a coworker's password to access Schoolmaster.
Was that Gail Wilson?
Yes, it was.
Okay. And so were you also able to determine whether or not Ms. Rowe changed any grades for student B?
Yes, I was able to receive a copy of the transcript as it had been printed on the 6th of April, 2016, and compared it with the transcript from that student the day prior on April 5th.
Okay, would those be in the record as Exhibit 3, pages 21 and 22? Are those the two different, the April 5 transcript and then the April 6 transcript? Pages, yes. Okay. And it looks like the GPA between the 2 days went from 2.987 to 3.139, and somebody circled on page 22 4 different grades that were increased from the 5th to the 6th, 3 English classes and a physical science class. Is that correct?
Yes, that's correct.
And did you have any special reason to know that the English grades were not correct?
Yes, because I was the English teacher at the time for student B.
Okay.
When she was a freshman in her sophomore year.
Okay. So, as a result, so what action was taken then with Ms. Williams-Rowe?
So after I had gone to the district office to speak with Dr. Goodwin and Erin Moya and the lawyers, we had a letter drawn up there at the office by Mary Hudson, who is the district secretary, and it was to tell Ms. Rowe that she was going to be working from home while we did the investigation. And Dr. Goodwin and I came back to South Verde, and we spoke with Sonia Williams-Rowe privately here at the school, and she was presented with the letter.
Okay, so did she admit or deny any of this?
Yes. She did. She denied.
Okay. So she was reassigned to home, and then what, did she just stay on reassignment to the end of the year and she was done?
Yes, she did come back to school, I believe, about a week later, week and a half later, and that was just to come by and collect some of her personal effects. And then she did not return on campus for the rest of the year.
Okay. So, okay, I don't think I have any other questions. Is there any other testimony you'd like to add today that you think might be helpful to the committee when they're deliberating and deciding this case?
Nothing that I can think of that hasn't already been spoken about.
Okay, thank you. I don't have any more questions, but the committee might.
Does the committee have any? Does the committee have any questions?
I have one.
Mr. Quario.
Did Ms. Rowe indicate to you why she changed the grades?
She didn't even admit to doing it.
She didn't admit doing it?
She did not admit to doing it.
I see. Thank you.
Are there any other questions? Dr. Sador.
How did this employee get her peers' password and login information? Any ideas?
Not exactly. There were a lot of opportunities, perhaps, when she had been in the office with Ms. Wilson that she could have watched as she was typing. That's a possibility, but I'm not 100% sure.
Okay, thank you.
Any other questions? All right, Ms. Sowell, you are excused as a witness. Thank you for appearing today.
Thank you.
Is there another witness in the room?
Yeah. Is Gail Wilson there?
Yes, I am.
Okay.
Ms. Wilson, this is Prudence Lee, the hearing officer. Will you raise your right hand?
Yes, I will.
Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
Yes, I will.
Thank you. Mr. Schwartz, the Assistant Attorney General, will now ask you questions.
Okay, thank you. Just really briefly. Ms. Wilson, what's your job title or where do you work?
I work at South Verde High School, which is part of Camp Verde Unified School District.
And what's your job title?
I am considered the administrative assistant.
Okay. And do you have access to the computer program known as Schoolmaster?
Yes, I do.
Okay. So, and do you have a login specific to you to get into Schoolmaster?
Yes, I do.
And did you ever give Sonia Williams-Rowe permission to use your login to get into Schoolmaster?
Not that I remember.
We didn't hear that. Could you repeat your answer?
Of course. No, not that I remember giving it to her.
Okay. And do you change student grades in Schoolmaster yourself?
I did at that time. No, excuse me. I'm going to take that back. No, I do not change grades. I put in grades in the Schoolmaster as when they finish the classes.
Okay, but you never go and then change grades in Schoolmaster?
No, sir. No,
Okay.
sir.
Okay. So did you ever change grades for the student we've identified as student B?
No, sir.
Okay, I have no further questions.
Does the committee have any questions for this witness? Hearing none. Ms. Wilson, you are excused. Thank you for appearing today. Mr. Schwartz, do you have another witness?
Briefly, Dion Murphy should be there.
I am here, yes.
Ms. Murphy, this is Prudence Lee, the hearing officer assigned to this matter. Please raise your right hand.
Okay.
Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
Yes, I do.
Thank you. Mr. Schwartz will now ask you questions.
Okay, Ms. Murphy, what's your job title?
That's a teacher at
I'm sorry, we could not. The phone is breaking up. Could you repeat your answer? Ms. Murphy, are you there? We seem to have lost the connection. Yeah. Kellen, can we try again?
Yeah, Hearing Officer Lee, I'll call them right back here.
Thank you so much.
I believe she's using a cell phone.
Sound like it.
In the Verde Valley, huh?
For 3 people.
They're booking tours.
Hello, Marisa.
Oh, yeah.
I can hear you now. Can you hear me okay? Okay, I'm going to conference you back in just a moment.
Hearing Officer Lee, they're back on the line.
All right. Ms. Murphy?
Yes, I'm here.
Okay, we lost your last transmission of the question. And Mr. Schwartz, if you can repeat the question.
Sure. I'll just cut to the chase. On April 6th of 2016, did you observe a student, we've identified a student B, approach Ms. Sonia Williams Rowe and discuss grades? Hello?
Ms. Murphy, are you there? Hello? Ms. Murphy?
Hello?
Ms. Murphy, this is Prudence Lee. Can you hear me?
Yes, I can hear you just fine.
Right.
Okay, I'll try one more time and then we can. Okay, can you hear me, Ms. Murphy?
Yes, I can hear you.
Okay, on April 6, 2016, were you in the lab at South Verde High School when you saw student B approach Sonia Williams Rowe?
Yes.
And what did you see and hear?
I was standing at the computer in the front of the room, and I was looking.
Ms. Murphy, your transmission is breaking up. Is there a landline available? We cannot hear your answers, so we are going to dispense with your testimony in this case.
Yeah, if I was going to say thank you, Ms. Murphy. I'll just tell Ms. Williams Rowe isn't here today, so we're just going to proceed. I'm sorry it didn't work out, but thank you.
You are excused, Ms. Murphy.
Okay, last one, Aaron Moya.
Hi, Aaron. Can you hear me okay? Hi, this is Kellen with the State Board of Education. If you're available now, I'm going to conference you in. Okay, just let me know when you're ready. Okay, I'll bring in the open meeting.
Hearing Officer Lee, I have Mr. Moya on the line.
Mr. Moya?
Yes, hello.
Hello, my name is Prudence Lee. I'm the hearing officer assigned to this matter. Could you raise your right hand, please?
Sure.
Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
Yes, I do.
Thank you. Mr. Schwartz, the Assistant Attorney General, will now ask you questions.
Okay, thank you. I'm just probably going to be pretty quick and brief on this, Mr. Moya, but back in April of 2016, were you the Director of Technology for the Camp Verde Unified School District?
Yes, I was.
Okay. And are you familiar with a woman named Sonia Williams Rowe?
I am, yes.
Okay, and how do you know her?
She was an employee at the South Verde campus when I was the director.
Okay. And do you have a set of the exhibits that were admitted into evidence here today that were sent to you before the hearing? Do you have those?
I sure do.
Okay. Could you look at Exhibit 5, pages 31 to 40?
Exhibit 5?
Yeah.
Okay.
Okay. Well, first I'll just ask, back in April of 2016, did Marie Zowell, or were you contacted by some, Camp Verde administration and asked to investigate whether Ms. Rowe had accessed Schoolmaster or the computer systems using someone else's login information?
Yes, I was.
Okay. And so did you do that investigation?
I did. And it looks like the supplemental information is within these exhibits here.
Okay, so are the exhibits, Exhibit 5, pages 31 through 40, and are those documents that you generated in your investigation or that you obtained?
Yes.
Okay.
Yes, that's correct.
If I could just ask you to briefly explain, especially page 31, could you just describe what that is, maybe start in the upper left? It looks like we kind of have a flow, little lines and arrows moving over, but if you could just kind of explain to everybody so everyone understands what we're looking at here.
Yeah, absolutely. So what we did is we set up roaming profiles and folder redirection, which allows users to log on to any machine and gives them access to their directories. And what you're looking at here is an Active Directory export of the user net logon, which basically means this person signed into XYZ machine. So in the top left, I have a little bubble that indicates, notice the machine name is not Gail's system. So you can see G. Wilson's username signed into SVHSTAID on multiple occasions. And if you go down the list, you can see that there's another machine name by SV-Gail, which was actually Gail Wilson's system that she used, that solely used. So you can see her logon information was used in multiple instances on the SVHSTAID. And what I have the bubble is going to here, I have several arrows. So going to the right, there's a Meraki client list printout. And Meraki was basically used to do device tracking. And you could also see the SVHSTAID device assigned to Sonia Williams Rowe.
Okay. So that's kind of in that top box, like on the top right, but what you just said, the SVHSTAID, and then next to that, S. Williams Rowe?
Yes.
So that's the machine that Ms. Williams Rowe used?
Yes.
Okay, thank you. Go ahead.
And right below that, there's user properties that were generated from the Active Directory that indicates the last logon, as well as the folder redirection policy showing the user profile was mapped over to the SVHSTAID system.
Okay, great. And then pages 32 to 40, are those, looks like maybe larger printouts of what was on page 31 in the left-hand column, showing all the dates, times, and then username. That means the time that Gail Wilson's login information we used to log in, and then machine name. We have the two here, the SVHSTAID, which indicated was Ms. Williams Rowe's machine, and the SV Gail, which was Gail Wilson's. Am I following?
Yes, absolutely.
Okay, so as a result of your investigation, you confirmed that in fact Ms. Williams Rowe had to use Ms. Wilson's login information to access the school?
Yes, that's correct.
Okay. And did you find that this had actually, we have a lot of pages. Had it happened before where Ms. Williams Rowe had used Ms. Wilson's login information to get into Schoolmaster?
Yes, in fact, there's several pages long here, but you could see essentially that Gail Wilson's logon was used on the SVHSTAID system on multiple occasions. So, for example, on, page 34,
Right.
121, 2016.
Sure.
Go down a little bit, and you could also see it on 9/11, 2015, and so on.
Sure. Okay, so pretty much anytime we see Gil Wilson logged into the SVH STID, that's Ms. Williams-Rowe.
Yes.
Okay. I don't have any further questions. Is there anything else you'd like to add you think might be helpful to the committee?
No, not really. I mean, it's pretty self-explanatory within the documentation. Hopefully my summary kind of, wraps these documents up.
Okay, thanks. I don't have any more questions, but the committee might.
Are there any questions from the committee? Ms. Sneed.
Thank you, Hearing Officer Lee. Is there evidence that in the prior times that Ms. Williams-Rowe accessed the student information system, Schoolmaster, that grades were changed at that time? So in other words, were grades changed on other occasions? Is there any evidence of that?
I wasn't in charge of administrating the SIS system, the student information system, in terms of managing grades and that sort. So that I wouldn't be able to give a yes or no to, because I'm not sure. All I was able to do was populate the instances in which the login was used on that machine.
Thank you.
Any other questions? All right, Mr. Moya, thank you for testifying. You are excused.
Thank you.
All right.
No, I have no further witnesses, so the state rests.
All right. Do you have closing argument?
Just briefly, the evidence presented here today, testimonial and documentary evidence is unrefuted, as Ms. Williams-Rowe isn't here, and preponderance of the evidence establishes that she used a co-worker's login information to get into a computer system that she wasn't authorized to access, to change grades she wasn't authorized to do, and that she got caught, and it constitutes unprofessional conduct under a number of grounds I believe I set forth in the complaint and the recommended decision, and the recommendation would be at a minimum a lengthy period of suspension of at least 3 years. Thank you.
Thank you, Mr. Schwartz. Having heard the testimony and reviewed the evidence, the committee will now discuss the case. Is there any discussion before we turn to the findings, the proposed findings of fact? Okay. The state has proposed findings of fact. Is there a motion on the findings of fact?
I move that we accept the findings of fact number 1 through 14.
Is there a second?
Second.
It's been moved and seconded that the committee adopt the findings of fact 1 through 14 as submitted by the Assistant AG. All in favor?
Aye.
Aye.
Opposed? The motion carries. Let us turn to aggravating factors. Are there any aggravating factors the committee would like to include in the findings of fact? Ms. Sneed?
Yes, I'd like to include E, refusal to acknowledge wrongful nature of conduct as evidenced by the respondents not being here today, and also as evidenced by her letter of resignation that just indicates that she was resigning due to being offered another position, and also due to testimony that at no point did she acknowledge to the district that she had done this unprofessional conduct.
Are there any objections to adding E, refusal to acknowledge wrongful nature of conduct, to aggravating factors? Hearing none. Are there any other aggravating factors the committee would like to add? All right. Are there any mitigating factors the committee would like to include?
I'd like to include A, absence of prior disciplined record.
Are there any objections to including A? Hearing none. Are there any more mitigating factors? All right, may I have a motion on both aggravating factors E and mitigating factors A?
I make a motion on aggravating factors E and mitigating factor A.
Is there a second?
Second.
It's moved and seconded that we add aggravating factor E, refusal to acknowledge wrongful nature of conduct, and mitigating factor A, absence of prior discipline record. All in favor?
Aye.
Aye.
Opposed? The motion carries. Conclusions of law. Is there a motion?
I motion that we accept conclusions of law, paragraphs 1 through 10, as presented.
Second.
Thank you. It's been moved and seconded that the committee adopt conclusions of law 1 through 10 as presented by the Assistant Attorney General. All in favor?
Aye.
Aye.
Opposed? The motion carries. We turn to the recommendation. Is there a recommendation from the committee?
I moved. Go ahead. I'll give it a sure moment.
All right. I make a recommendation that the PPAC recommend to the State Board that State Board take disciplinary action to suspend the respondents, Ms. Rose, suspend any and all certificates for 1 year, and that all states and territories are notified.
Is there a second? Motion dies for lack of a second. Is there another motion?
May I address the committee? I was going to move to revoke, but there's a long ways between Mr. Correa, who I respect very much, and mine. So I would look to other committee members to move something in between.
Well, Member Sampson, my initial thought was to revoke also, given the level of dishonesty and lack of personal integrity that implies.
I agree. There's definitely poor judgment. There's lack of integrity. But does it raise the level of drugs? Does it raise the level of criminal? There's no criminal component here. That's why my view is that the response does need some consequences, discipline. But compared, and I think comparatively to the other instances that we've had that warrant, that we've recommended revocation, they're very different. I think a lot more serious, and typically include criminal behavior, and typically include prior record, prior infractions, multiple offenses, those kinds of things.
Ms. Williams, you're at the podium. Do you wish to
Hearing Officer Lee,
comment?
members of the committee, I just want to stress that it is important that we do motion, a second, then discussion, and then vote, just following the normal proceedings.
Thank you, Ms. Williams.
I appreciate the instruction. However, the motion had failed. I feel I was allowed to address that motion. So, but I will make a new motion, and maybe we can discuss it more. I move that we strike that, please, Angela. Based on the findings of fact and conclusions of law above, I move that the PPAC recommend the board take disciplinary action through suspension for 3 years of any and all respondents to teaching certificates, and that all states and territories be notified.
Is there a second?
Second.
It's been moved and seconded that based on the findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through suspension for 3 years of any and all of respondents' teaching certificates, and that all states and territories be so notified. Is there any further discussion? Kellen, would you take the roll?
Member Correa?
Aye.
Member Kreider?
Aye.
Member Sadorf?
Aye.
Member Sneed?
Aye.
Chairman Sampson?
Aye.
5 ayes.
By your vote of 5-0, you have recommended a suspension for 3 years for Sonia Williams-Rowe. This concludes the formal hearing. The committee Its decision will be reduced to a written recommendation and delivered to the Board of Education. The board will make the final decision. Each party will receive notice of the board meeting at which it will consider the committee's recommendations. The parties have further appeal rights that will be explained on the final order issued by the Board of Education. Is there an executive director's report?
Members of the PPAC committee, a couple things. Member Sampson, Member Kreider, your terms are up on July 31st, 2018. So if you could please email myself and Director of Special Projects, Mr. White, so that we know whether or not you would like to reapply for the position or if you would like to resign your position. In addition to that, I just want to make the PPAC members aware that whether or not Member Sampson and Member Kreider choose to reapply for the position, this PPAC will have 2 lay member positions open, 1 secondary teacher position open come July. PPAC number 1 has a principal position in which her term is expiring. And then I also have a governing board member position open. So if you know of anybody who you think would be beneficial to the work that all of you do, please direct them in to board staff so we can get them situated and approved by the board prior to any meetings in which we can't meet quorum.
Thank you, Ms. Williams. Is there anything else from the committee? We stand adjourned at 12:05 p.m. Thank you very much.